Okay, I'm live. I'm going to read Module 5 of the CMR about criminal procedure. This module is about the exclusionary rule. 6.1, in general, scope of the rule. The exclusionary rule is a judge-made doctrine that prohibits introduction of evidence obtained in violation of a defendant's 4th, 5th, and 6th Amendment rights under the rule. Unconstitutionally obtained evidence inadmissible at trial, and all fruit of the poisonous tree, that is, evidence obtained from exploitation of the unconstitutionally obtained evidence, must also be excluded unless the cause of excluding the evidence outweigh the deterrent effect exclusion would have on police conduct. Exceptions to fruit of the poisonous tree doctrine. Which is in 4 parts here, three parts with a caveat to the third. The fruits derived from statements obtained in violation of Miranda, evidence obtained from a source independent of the original illegality, and evidence for which, this is the third, the connection between the unconstitutional police conduct and the evidence is remote, considering whether the misconduct was purposeful or flagrant or has been interrupted by some intervening circumstance, and so that the causal link between the police misconduct and the evidence is broken. In parentheses, end quotes, they call this attenuation, and give an example. And the caveat to the third point is this includes intervening acts of free will on the part of the defendant. So those were oddly exceptions to the fruit of the poisonous tree. So those deriving from violations of Miranda, those also where a source obtained from a source independent of the original illegality, and when there's attenuation, breaking the causal link between the police misconduct and evidence. Acts of free will, like intervening acts of free will, are included in that. Inevitable discovery. Oh, there's a couple more exceptions. There's inevitable discovery and violations of the knock and announce rule. So inevitable discovery is the only one that has a couple additional sentences. The prosecution can show that the police would have discovered the evidence whether or not the police acted unconstitutionally. 6.1.1, live evidence testimony. What does this include? It is difficult to have live witness testimony excluded on exclusionary rule grounds. 6.2.1, in-court identification. A defendant may not exclude a witness in-court identification on the ground that is the fruit of an unlawful detention. Right? Out-of-court identifications. Unduly suggestive out-of-court identifications that create a substantial likelihood of misidentification. That created substantial likelihood of misidentification can violate the due process clause of the 14th Amendment. Whether an identification procedure is unduly suggestive is judged on a case-by-case basis under the totality of the circumstances. However, the court will not consider applying the exclusionary rule unless the unnecessarily suggestive circumstances were arranged by the police. 6.2, limitations of the rule. 6.2.1, inapplicable to grand juries, civil proceedings, violations of state law, internal agency rules, the parole revocation proceedings. The exclusionary rule is inapplicable to grand juries unless evidence was obtained in violation of the federal wiretapping statute. The rule is also inapplicable at parole revocation hearings, in civil proceedings, or where evidence was obtained contrary only to state law or agency rules. And 6.2.2, good faith reliance on law, defective search warrant, or clerical error. The exclusionary rule does not apply when the police arrest someone erroneously but in good faith, thinking that they are acting pursuant to a valid arrest warrant, search warrant, law. There are 4 exceptions to a good faith reliance on a defective warrant. Those include 1, the affidavit underlying that warrant is so lacking in probable cause that no reasonable police officer would have relied on it. So that's an exception to the good faith reliance on a defective warrant. The second is the affidavit underlying the warrant is so lacking in particularity that no reasonable officer would have relied on it. Sounds exactly the same. But the difference is this one's not lacking in probable cause as the last, but lacking in particularity. The third would be where the police officer or prosecutor lied to or misled the magistrate when seeking a warrant. And fourth, the magistrate is biased and therefore has wholly abandoned their neutrality. But I find that to be correct. I just think it doesn't necessarily fit in the good faith reliance on the defective warrant. Like, that's a defective warrant, certainly, where you lied to the magistrate or the magistrate's biased. But I did not know that a police officer's good faith reliance on that warrant would be would be excluded, right? So I have a hard time kind of following that. So let me get back to the beginning of this section. The exclusionary rule does not apply when there's a good faith reliance, except in these 4 circumstances. So in such case, the exclusionary rule would bar defective warrant of those 4 types. So that's a good thing. All right. Sorry, just printing something. All right, let's move on. Use of excluded evidence for impeachment purposes. Some illegally obtained evidence may still be used to impeach the defendant's credibility if they take the stand at trial. Specifically, an otherwise voluntary confession taken in violation of the Miranda requirements is admissible for impeachment purposes, and evidence obtained from an illegal search may be used by the prosecution to impeach the defendants, but not the other statements. Knock and announce rule violation. Exclusion is not an available remedy for violations of the knock and announce rule pertaining to the exclusion of a warrant. Exclusion is not an available remedy for violations of the knock and announce rule pertaining to the execution of a warrant. Harmless error test. If illegal evidence is admitted, I'm surprised how short that section is. Sorry, harmless error test. If illegal evidence is admitted, a resulting conviction should be overturned on appeal unless the government can show beyond reasonable doubt that the error was harmless. The conviction will be upheld if it would have resulted despite the improper evidence in a habeas proceeding where the petitioner claims constitutional error. The petitioner should be released if they can show the error had substantial and injurious effect or influence in determining the jury's verdict. If the judge is in grave doubt as to the harm, the petition must be granted. Harmless error standard never applies to the denial of the right to counsel at trial. This trial is never harmless. Enforcing 6.4. Enforcing the exclusionary rule. Just gonna grab my coffee. Try to print the thing again and grab my coffee. Let's not have ink. My Bubba thinks he has a treat. This is mommy's coffee. It's no treat. He's sleepy. Now, in enforcing the exclusionary rule, the defendant is entitled to have the admissibility of evidence or a confession decided as a matter of law by a judge out of the hearing of the jury. The government bears the burden of establishing the admissibility of a preponderance of by a preponderance of the evidence. The defendant has the right to testify at suppression hearing without the testimony being admitted against them on trial on the issue of guilt. Module 7, Pretrial Procedures. Preliminary hearing to determine probable cause to detain. A defendant, no preliminary hearing to determine probable cause need be held. If probable cause has not been what's this say? It's so far away. Has not already been determined, and there are significant constraints on the arrestee's liberty, for example, jail on bail, but not release on reconnaissance. A preliminary hearing to determine probable cause must be held within a reasonable time, for example, 48 hours. The hearing is informal, non-adversarial proceeding. There is no real remedy for a denial of the hearing, but evidence discovered as a result of an unlawful detention can be excluded under the exclusionary rule. Pretrial detention bail. Most state constitutions create a right to be released on bail unless the charge is a capital one. Generally, bail can be set no higher than is necessary to assure the defendant's appearance at trial. Refusal to grant bail on the setting of excessive bail may be appealed immediately. However, the Supreme Court has upheld portions of the Federal Bail Reform Act that allow arrestees to be held without bail if they pose a danger or will fail to appear at trial. Defendant competent to stand trial. Standards for commitment and subsequent release of defendants incompetent to stand trial must be essentially identical with those for commitment of persons not charged with a crime. Otherwise, there is a denial of equal protection. Grand juries. Use of grand jury. The Fifth Amendment right to indictment by grand jury has not been incorporated into the 14th Amendment, but some state constitutions require grand jury indictment. Most states east of the Mississippi and the federal system use the grand jury as a regular part of the charging process. Western states generally charge by a filing of information, a written accusation of the crime prepared and presented by the prosecution. Grand jury proceedings. Secrecy and defendant's lack of access. Grand jury proceedings are conducted in secret. The defendant has no right to notice, and the grand jury no right to notice that the grand jury is considering an indictment against them, to be present and confront witnesses at the proceeding, or to introduce evidence before the grand jury. No right to counsel or Miranda warnings. A witness subpoenaed to testify before the grand jury does not have the right to receive Miranda warnings, nor is the witness entitled to a warning that there are potential that they are a potential defendant when called to testify before the grand jury. Witnesses have no right to have an attorney present. C. No right to have evidence excluded. A grand jury may base its indictment on evidence that would be inadmissible at trial, and an indicted defendant may not have the indictment quashed and on the ground that it is based on illegally obtained evidence. No right to challenge subpoena. There's no right to challenge a subpoena on the Fourth Amendment grounds that the grand jury lacked probable cause or any reason at all to call a witness for questioning. Exclusion of minorities. A conviction resulting from an indictment issued by a grand jury from which members of a minority group have been excluded will be reversed without regard to harmlessness of error. Speedy trial. A determination whether a defendant's Sixth Amendment right to a speedy trial has been violated is made by an evaluation of the totality of the circumstances. Factors considered are the length of delay, reason for delay, whether defendant asserted their rights, and prejudice to the defendant. The remedy for a violation of the right to a speedy trial is dismissal with prejudice. When right attaches. The right of speedy trial does not attach until the defendant has been arrested or charged. The defendant is charged and is incarcerated in another jurisdiction. Reasonable efforts must be used to obtain the presence of the defendant. Also, it is a violation of the right to speedy permit the prosecution to indefinitely suspend charges. Note, the defendant does not need to know of the charges for the speedy trial right to attach. 7.5 Prosecutorial duty to disclose exculpatory information and notice of defenses. 7.5.1 Prosecutor's duty to disclose exculpatory evidence. The government has a duty to disclose material exculpatory evidence to the defendant. Failure to disclose such evidence, whether willful or inadvertent, violates a due process clause and is grounds for reversing a conviction if the defendant can prove that 1. The evidence is favorable to the defendant because it either impeaches or is exculpatory, and 2. Prejudice has resulted, that is, there would be a reasonable probability that the result of the case would have been different if the undisclosed evidence had been presented at trial. Is this Brady violation? Notice of alibi and intent to present insanity defense. If the defendant is going to use an alibi or insanity defense, they must notify the prosecution. If an alibi is to be used, the defendant must give the prosecution a list of their witnesses. The prosecution must give the defendant a list of the witnesses it will use to refute the defense. The prosecutor may not comment at trial on the defendant's failure to produce a witness named as supporting the alibi or on failure to present the alibi itself. Page 52. Competency to stand trial. Competency and insanity distinguish. Insanity is a defense to a criminal charge based on the defendant's mental condition at the time they committed the crime. The defendant, acquitted by reason of insanity, may be retried and convicted, although they may be hospitalized under some circumstances. Incompetency to stand trial, on the other hand, is not a defense to the charge, but rather is a bar to trial. It is based on the defendant's mental condition at the time of trial. If the defendant later regains competency, they can then be tried and convicted. Due process standard. A defendant is incompetent to stand trial if they either 1. Lack a rational as well as a factual understanding of the charges and proceedings, or 2. Lack sufficient present ability to consult with their lawyer with a reasonable degree of understanding The state may place on the defendant the burden of proving incompetency by a preponderance of the evidence, but requiring the defendant to show incompetency by clear and convincing evidence is unconstitutional. Detention of defendant. A defendant who has successfully asserted the insanity defense may be confined to a mental hospital for a term longer than the maximum period of incarceration for the offense. However, the defendant cannot be indefinitely committed after regaining sanity merely because the defendant is unable to prove themselves not dangerous to others. And pretrial publicity. Excessive pretrial publicity prejudicial to the defendant may require change of venue or retrial. Trial, the basic right to a fair trial. Order of arguments. Trial begins with this is Module 8, by the way. Trial begins with the opening argument of the prosecution, followed by defense's opening argument. Closing arguments proceed in the following order. 1, the government argues. 2, the defense argues. And 3, the government rebutes. Right to public trial. The 6th and 14th Amendment guarantee the right to a public trial, but the right varies with the stage of the proceeding involved. Pretrial proceedings. Preliminary probable cause hearings are presumptively open to the public and the press, and as are pretrial suppression hearings. Although the latter may be closed to the public under limited circumstances, for example, the party seeking closure has an overriding interest likely to be prejudiced. By disclosure, and there is no reasonable alternative besides closure. Similarly, a court must make every reasonable effort to accommodate public attendance at jury voir dire hearings. All right, he's done being petted, so let's get him off the ground. So voir dire is open too. What else do we have? Trial. The press and public have a First Amendment right to attend the trial itself, even when the defense and prosecution agree to close it. The state may constitutionally permit televising criminal proceedings over the defendant's objection. Right to unbiased judge. Due process is violated if the judge is shown to have actual malice against the defendant or to have had a financial interest in having the trial result in a guilty verdict. Impermissible bias is also present when a judge earlier had significant personal involvement as a prosecutor in a critical decision regarding the defendant's case. Page 54. Must judge be a lawyer? A defendant in a minor misdemeanor prosecution has no right to have their trial judge be a lawyer if, upon conviction, the defendant has a right to trial de novo in a court with a lawyer judge, but for serious crimes, a judge probably must be law trained. Other due process rights. The due process is violated if the trial is conducted in a manner making it unlikely that the jury gave the evidence reasonable consideration. The state compels the defendant to stand trial in prison clothing. The state compels the defendant to stand trial or appear at penalty phase proceedings visibly shackled unless the court finds the shackling justified by concerns about courtroom security or escape, or the jury is exposed to influence favorable to the prosecution. Due process does not require the police to preserve all items that might be used as exculpatory evidence at trial, but does prohibit bad faith destruction. Now, right to trial by jury. Right to trial, jury trial, only for serious offenses. There is no constitutional right to jury trial for petty offenses, but only for serious offenses. An offense is serious if imprisonment for more than 6 months is authorized. Also, there is no right to jury trial in juvenile delinquency proceedings. And 10. For civil contempt proceedings, there is no jury trial right. For criminal contempt proceedings, cumulative penalties totaling more than 6 months cannot be imposed without affording the defendant the right to a jury trial. If a judge summarily imposes punishment for contempt during trial, penalties may aggregate more than 6 months without a jury trial. Probation. A judge may place a contemptor on probation for up to 5 years without affording them the rights to a jury trial, as long as revocation of probation would not result in imprisonment for more than 6 months. Number and unanimity of jurors. There is no constitutional right to a jury of 12, but there must be at least 6 jurors to satisfy the right to a jury trial. Jury verdicts must be unanimous. Right to veneer selected from representative cross-section of community. A defendant has the right to have the jury selected from a representative cross-section of the community. The defendant need only show the underrepresentation of a distinct, and you okay? Distinct and numerically significant group of the veneer to show their jury trial right was violated. Note that the defendant does not have the right to proportional representation of all groups on a particular jury. All right, use of peremptory challenges for racial and gender-based discrimination. Although generally a prosecutor may exercise peremptory challenges for any reason, the Equal Protection Clause forbids the use of peremptory challenges to exclude potential jurors solely on account of their races or gender. An equal protection-based attack on peremptory strikes involve 3 steps. The defendant must show facts or circumstances that raise an inference that the exclusion was barred on race or gender. 2. Upon such a showing, the prosecutor must come forward with race-neutral explanation for the strike. Even an unreasonable explanation is sufficient as long as it is race-neutral. 3. The judge then determines whether the prosecutor's explanation was the genuine reason for striking the juror or merely a pretext for purposeful discrimination. If the judge believes the prosecutor was sincere, the strike may be upheld. Right to impartial jury. Standard: impair or prevent performance. The standard for determining when a prospective juror should be excluded for cause is whether the juror's views would prevent or substantially impair the performance of their duties in accordance with the instructions and oath. Right to questioning on racial basis. A defendant is entitled to questioning on voir dire specifically directed to racial prejudice whenever race is bound up in the case or the defendant is accused of an interracial capital crime. Juror opposition to the death penalty. In capital punishment cases, a state may not automatically exclude for cause all of those who express a doubt or scruple about the death penalty. It must be determined whether the jurors' views would prevent or substantially impair performance of their duties in accordance with their instructions and oath. A death sentence imposed by a jury from which a juror was improperly excluded is subject to automatic reversal. Jury favoring death penalty. If a jury is to decide whether a defendant is to be sentenced to death on voir dire, the defendant must be allowed to ask potential jurors if they would automatically give the death penalty upon a guilty verdict. A juror who answers affirmatively must be excluded for cause because such a juror cannot perform their duties in accordance with instructions as to mitigating circumstances. Use of peremptory challenge to maintain impartial jury. If a trial court refuses to exclude for cause a juror whom the court should exclude, and the defendant uses a peremptory challenge to exclude the juror, there is no constitutional violation. inconsistent verdicts. Inconsistent verdicts, for example, finding the defendant guilty and co-defendant not guilty on the same evidence are not reviewable. Sentence enhancement. If substantive law provides that a sentence, so I just read that alone to myself. So it might be relevant to say this again. In the area of inconsistent verdicts, when, say, for example, the defendant is found guilty and the co-defendant not guilty on the same evidence, are not reviewable. So, reviewable by who? Together on appeal? Separate on appeal? What do they mean? Anyway, that's why I had to read that alone to myself, because I'm not sure I'm following, because it's new information to me. But for sentence enhancement on page 57, if substantive law provides that a sentence may be increased beyond a statutory maximum for a crime, if additional facts other than prior conviction are proof of the facts must be submitted to the jury and proved beyond reasonable doubt, the defendant's right to jury trial is violated if the judge makes a determination. The same general rule applies to setting the amount due on a fine. If the amount is based on facts, there is a right to have a jury find those facts. The same rule also applies to sentencing enhancements after guilty pleas. In deciding whether to overturn a sentence for failure to submit a sentencing factor to the jury, the harmless error test is applied. Let's keep going. Never going to get to a sentencing question in the bar. Maybe in real life. IRL. Judge may decide whether sentences run consecutively. A state legislature may give to judges rather than the jury the power to decide whether sentences for multiple crimes are to run consecutively or concurrently, even though the decision is based on the facts of the case. Right to counsel. A defendant has a right to counsel. Violation of this right at trial, including erroneous disqualification of the defendant's privately retained counsel, requires reversal. For non-trial denials, the harmless error test is applied. Waiver of right to counsel at trial and right to defend oneself. A defendant has a right to defend himself at trial in the judgment of the judge. Their waiver is knowing and intelligent and based on the trial judge's consideration of the defendant's emotional and psychological state. A defendant is competent to proceed pro se. Note that a defendant does not have a right to self-representation on appeal. Indigence and recoupment of cost. The state generally provides counsel in closed cases of indigence, but may then seek reimbursement from those convicted defendants who later become able to pay. Oh, what's that noise? Okay. Ineffective assistance of counsel. The Sixth Amendment right to counsel includes the right to effective counsel. This right extends to the first appeal. Effective assistance of counsel is generally presumed. Circumstances constituting ineffective assistance. An ineffective assistance claimant must show deficient performance by counsel, and before the deficiency, the result of the proceeding would have been different. For example, the defendant would not have been convicted on, or the sentence would have been shorter. The defendant must point out specific deficiencies and cannot base the claim on inexperience, lack of time to prepare, the gravity of the damages, the complexity of defenses, or accessibility of witnesses to counsel. Note, if counsel admits their client's guilt in the face of the defendant clearly articulated desire to do what? To maintain their innocence during the sentencing phase of trial, the structural error mandates a new trial without any need to show prejudice. Now, plea bargain cases. To make out a Sixth Amendment ineffective assistance claim in a plea bargain case, the defendant must show deficient performance and a reasonable possibility that the outcome of the plea process would have been different with competent advice. An attorney's failure to notify a defendant of a plea offer can constitute deficient performance if the defendant can show that 1. Had the plea agreement been communicated, the defendant likely would have accepted, and 2. The plea likely would have been entered without the prosecution's canceling it. The fact that the defendant subsequently has a fair trial after turning down a plea offer does not prevent the ineffective assistance claim. Deportation risk. It is constitutionally deficient for counsel not to inform a client whether their plea carries a risk of deportation. And circumstances not constituting ineffective assistance. Circumstances not constituting ineffective assistance include trial tactics and the failure to raise a constitutional defense that is later invalidated. Conflicts of interest. Joint representation is not per se invalid. However, if an attorney advises the trial court of a resulting conflict of interest at or before trial, and the court refuses to appoint separate counsel, the defendant is entitled to automatic reversal. Conflict with attorney. So we're talking about joint representation. It can be reversed if the court refuses to appoint separate counsel ahead of trial, at or before trial, if the attorney advises of a potential conflict at that time. Conflict with attorney. A defendant's conflict of interest with their attorney is rarely a ground for relief. No right to joint representation. A defendant has no right to be jointly represented with defendants if the government can show a potential conflict of interest. Right to support services for defense. Where a defendant has made a preliminary showing that they are likely to be able to use the insanity defense, the state must provide a psychiatrist for the preparation of the defense. Seizure of funds constitutional. The right to counsel does not forbid the seizure of drug money or property obtained with drug money, even where a defendant was going to use such money to properly pay an attorney, or property to pay an attorney. Right limited while testifying. The defendant has no right to consult with their attorney while testifying and may be sequestered from their attorney during short breaks, for example, 15 minutes as opposed to overnight. Right to confront witnesses. The Sixth Amendment grants to a defendant in a criminal prosecution the right to confront adverse witnesses. The right is not absolute. Face-to-face confrontation is not required when preventing such confrontation serves an important public purpose. For example, protecting child witnesses from trauma. Also, a judge may remove a disruptive defendant, and a defendant may voluntarily leave the courtroom during trial. So it's not an absolute right, a face-to-face confrontation, especially if it protects children, and disruptive defendants may be removed notwithstanding their right to confront witnesses. Introduction of co-defendant confession. If two persons are tried together and one has given a confession that implicates the other, the right of confrontation prohibits use of that statement even where the confession interlocks with the defendant's own confession, which is admitted. However, such a statement may be admitted if all portions referring to the other defendant can be eliminated, the confessing defendant takes the stand and subjects themselves to cross examination with respect to the truth or falsity of what the statement asserts, or the confession of the non testifying co defendant is being used to refute the defendant's claim that their confession was obtained coercively. Prior testimonial statement of unavailable witness under the Confrontation Clause. Prior testimonial evidence, for example, statements made at prior judicial proceedings, may not be admitted unless the declarant is unavailable and the defendant had an opportunity to cross-examine the defendant at the time the statement was made. What is testimonial? The court has not provided a comprehensive definition of the term testimonial, but it has held that it includes, at a minimum, statements from a preliminary hearing, a grand jury hearing, a formal trial, or police interrogation conducted to establish or prove past acts. However, statements from police interrogation intended to aid the police responding to an ongoing emergency, such as answering a 911 operator's question while reporting a crime in progress, are not testimonial. Statements to individuals who are not principally charged with uncovering and prosecuting crimes are subject to the Confrontation Clause, but they are significantly less likely to be testimonial than statements given to police officers. Results of forensic lab testing. If results of forensic lab tests are offered for proof of the matter asserted, for example, testimony from a lab technician that powder found on the defendant is cocaine, they are testimonial in nature and inadmissible unless the person who did the testing is made available for cross-examination. However, no Confrontation Clause issue is raised when the lab test results are not offered. To prove the validity of the test results, for example, testimony that the results from a private lab match results from the state lab, offered to show the results match, not that the private lab results are correct. Forfeiture by wrongdoing. So they're just like sneaking in all these evidence concepts in at the very end of Module 8. And I just keep getting incredibly distracted by so we just talked about what's testimonial, and we're talking about an ongoing emergency versus like, crime deterrence versus like building a case. I just keep thinking about class. Results of forensic lab testing. It was the last section, and they're saying that there's no Confrontation Clause issue raised when the lab test results are not offered. To prove the validity of the test results, for example, testimony that the results from a private lab match results from a state lab, offered to show the results match, not that the private lab results are correct. So that was unexpected. Probably the first part of that section is most important, which is like if results of forensic lab tests are offered for the proof of the matter asserted, for example, testimony from a lab technician that powder found on the defendant is cocaine, they are testimonial in nature and inadmissible unless the person who did the testing is made available for cross-examination. So there you go. That's what's really important. All this other stuff about now there's two labs and one lab's doing this to do that. No. To prove that the first lab was correct. Okay, well, it sounds to me like that would be admissible because it's not for the proof of the matter asserted. So, forfeiture by wrongdoing. A defendant can be held to have forfeited a Confrontation Clause claim by wrongdoing. However, the court will not find a forfeiture by wrongdoing unless the wrongdoing was intended to keep the witness from testifying. For example, a statement made to the police by a victim who was later killed by the defendant cannot be admitted in the defendant's murder trial absent evidence that the defendant murdered the victim to keep them from testifying. All right. Burden of proof, sufficiency of evidence, and jury instructions. The Due Process Clause requires, in all criminal cases, that the state prove guilt beyond reasonable doubt. The presumption of innocence is the basic component of a fair trial. However, the state may generally impose a burden of proof upon the defendant in regard to the affirmative defense, such as insanity or self-defense. Presumptions. A mandatory presumption, or a presumption that shifts the burden of proof to the defendant, violates the 14th Amendment's requirement that the state prove every element of the crime beyond a reasonable doubt. Jury instructions. A judge is to give a jury instruction requested by the defendant or the prosecution if the instruction is correct, has not already been given, and is supported by some evidence. So, Module 9 is about guilty pleas and plea bargaining, taking plea, advising defendants of the charge and the potential penalty and their rights. The judge must determine that the plea is voluntary and intelligent. This must be done by addressing the defendant personally in open court on the record. Specifically, the judge must be sure that the defendant knows and understands things such as 1. The nature of the charge to which the plea is offered and the crucial elements of the crime charged, the maximum possible penalty and any mandatory minimum, and that the defendant has a right not to plead guilty, and that if they do plead guilty, they waive the right to trial. Attorney may inform defendant. That's literally the name of the section. The judge need not personally explain the elements of each charge to the defendant on the record. It is sufficient that the record reflects the nature of the charge and the elements of the crime are explained to the defendant by their own counsel. Remedy. The remedy for a failure to meet the standards for taking a plea is withdrawal of the plea and pleadings anew. Collateral attacks on guilty pleas after sentence. Those pleas that are seen as an intelligent choice among the defendant's alternatives are immune from collateral attack, but a plea can be set aside for involuntariness, failure to meet standards for taking a plea, 2. Lack of jurisdiction, 3. Ineffective assistance of counsel, 4. Failure to keep the plea bargain. Plea bargaining. A plea bargain will be enforced against the prosecutor and the defendant, but not against the judge who does not have to accept the plea. A guilty plea is not involuntary merely because it was entered in response to the prosecution's threat to charge the defendant with a more serious crime. If they do not plead guilty, there is no prosecutorial vindictiveness in charging a more serious offense when defendant demands a jury trial. So maybe at one point there was, but it's saying here no. There's nothing. That's the last sentence of that section. Clear, black, and white. So I might have read something different in my book, but it says right here, there is no prosecutorial vindictiveness in charging a more serious offense when defendant demands a jury trial. Collateral effects of guilty pleas. A guilty plea conviction may be used as a conviction in other proceedings when relevant, for example, as the basis for sentence enhancement. However, a guilty plea neither admits the legality of incriminating evidence nor waives Fourth Amendment claims in a subsequent civil damages action. I get so distracted by these things. There was something that distracted me earlier too, so let me go back to it before we go into Module 10. Collateral effects of guilty pleas. The guilty plea conviction may be used as a conviction in other proceedings when relevant, for example, as the basis of a sentence enhancement. However, a guilty plea neither admits the legality of incriminating evidence nor waives Fourth Amendment claims in subsequent civil damages actions. Neither admits the legality of incriminating evidence nor does. Okay. So that's a lot. And I don't want to completely turn over everything that I thought that I knew from evidence. But this is one section I'm going to read. Some commenting on this. I guess that's going back too far. Going back too far. Was it ineffective assistance? So the defendant, if counsel admits their client's guilt in the face of the defendant's clearly articulated desire to maintain their innocence during the sentencing phase of trial, this structural error mandates a new trial without any need to show pressure. Okay, that's fine. There's nothing unusual about that sentence, or that paragraph. So going back to module 10, after we just talked about the lovely trial, evidence plea, constitutional problems on appeal. 11.1, I feel like a lot has changed in this area because I don't remember this. 11.1, no right to appeal. There is no federal constitutional right to an appeal. 11.2, equal protection and right to counsel on appeal. If an avenue of post-conviction review is provided, conditions that make the review less accessible to the poor than to the rich violate equal protection. Thus, indigents must be given counsel at state expense during the first appeal granted to all as a matter of right. And for appeal, so what does that mean? Like, why is that? Why does that seem like it contradicts the earlier section? So I'm gonna read this one more time. It's 2 sections. I simply am confused because I feel that I learned this first appeal granted to all as a matter of right, and maybe I misunderstood it, but that sounded right based on what I learned in criminal law, first year criminal law. So page 69, module 11, constitutional problems on appeal. 11.1, titled No Right to Appeal. With only this very short sentence, there is no federal constitutional right to an appeal, period, end of sentence, end of section. 11.2, titled Equal Protection and Right to Counsel on Appeal. Reading, if an avenue of post-conviction review is provided, conditions that make the review less accessible to the poor than to the rich violates equal protection. Thus, indigents must be given counsel at state expense during a first appeal granted to all as a matter of right, and for appeals of guilty pleas and pleas of no contest. All right, so the counsel is a matter of right on appeal, but the appeal is not a matter of right. I wonder how I got so confused. In a jurisdiction using a 2-tier system of appellate courts with discretionary review by the highest court, an indigent defendant need not be provided with counsel during the second discretionary appeal. Again, it's a discretionary appeal. Retroactivity. If the Supreme Court announces a new rule of criminal procedure, for example, one not dictated by precedent in a case on direct review, the rule must be applied to all other cases on direct review. Module 12, Collateral Attack Upon Conviction. 12.1, Availability of Collateral Attack. After appeal is no longer available or has proven unsuccessful, defendants may generally still attack their convictions collaterally. 12.2, Habeas Corpus Proceeding. An indigent has no right to appointed counsel at a habeas corpus proceeding. Petitioner has the burden of proof by preponderance of evidence to show an unlawful detention. The state may appeal the grant by a writ of habeas corpus. A defendant generally may bring a habeas petition only with the defendant in custody. Generally, this includes anyone who has not fully served the sentence about which they wish to complain. Module 13, Right to counsel at parole and probation revocation. If revocation of probation also involves imposition of a new sentence, the defendant is entitled to representation by counsel in all cases in which they are entitled to counsel at trial. If after probation revocation an already imposed sentence of imprisonment springs into application, or if the case involves parole revocation, the right to counsel is available only if representation is necessary to a fair hearing. For example, the defendant denies commission of alleged acts or issues are otherwise difficult to present and develop. Prisoners' rights. Prisoners' rights issues rarely appear on the multi-state bar exam, and when they do appear, they usually involve the same constitutional analysis as set out in the general constitutional law outline. The most important rules peculiar to criminal procedure are due process. Prison regulations impinge on due process rights only if the regulations impose atypical and significant hardship in relation to the ordinary incidents of prison life. No Fourth Amendment protection in cells. Prisoners have no reasonable expectation of privacy in their cells and so have no Fourth Amendment protection with respect to searches of their cells. Right of access to courts. Reasonable access to the courts. First Amendment rights. Prisoners' First Amendment rights of freedom of speech, association, and religion may be burdened by regulations reasonably related to penological interests. For example, running a safe and secure prison. Note that incoming mail can be broadly regulated, but outgoing mail generally cannot be regulated. Note also that the federal statute prohibits states from interfering with the prisoner's religious practices absent a compelling interest. Right to adequate medical care. Prisoners have a right to adequate medical care under the Eighth Amendment prohibition against cruel and unusual punishment. And lastly, no right to be free from disabilities upon completion of sentence. A person convicted of a felony may be unable to vote in state elections, and this disability can constitutionally continue beyond the term of the sentence. Module 14, double jeopardy. When jeopardy attaches. Under the Fifth Amendment, a person may not be retried for the same offense once jeopardy is attached. Jeopardy attaches in a jury trial at the impaneling and swearing of the jury. In bench trials, jeopardy attaches when the first witness is sworn. Commencement of a juvenile proceeding bars a subsequent criminal trial for the same offense. Jeopardy generally does not attach in civil proceedings other than juvenile proceedings. Exceptions permitting retrial. Certain exceptions permit retrial of a defendant even if jeopardy has attached. A state may retry a defendant whose first trial ends in a hung jury. A trial may be discontinued and the defendant re-prosecuted for the same offense when there is manifest necessity to abort the original trial or when termination occurs at the behest of the defendant on any ground not constituting acquittal on the merits. A state may retry a defendant who has successfully appealed a conviction unless the ground for reversal was insufficient evidence to support a guilty verdict. Retrial is permitted when reversal is based on the weight rather than sufficiency of the evidence. However, on retrial, a defendant may not be tried for a greater offense than that for which they were convicted. A harsher sentence may be imposed for reasons other than vindictiveness for taking an appeal. But if the jury found that the death penalty was not appropriate in the first trial, a death sentence may not be imposed on the second trial. So I'm feeling like the next thing that they have to say here is and is not being said here is when someone dies between the charge and the conviction, and the charge was like not for manslaughter, but now it is within a year. Is that one of the notes that they said? Oh yeah. No. Charges may be reinstated after a defendant breaches the plea bargain, and if a defendant could have been tried for multiple charges in a single trial, but the defendant elects to have the offenses tried separately, jeopardy does not attach to the first trial for the other charges. And so they've severed these separate charges and elect to do so. Therefore, jeopardy does not attach to the first trial for the other charges. Same offense, 14.3. General rule: when two crimes not the same offense. Two crimes are not the same offense unless each crime requires proof of an additional element that the other does not require, even though some of the same facts may be necessary to prove both crimes. Cumulative punishments for offenses constituting the same crime. Even if two crimes constitute the same offense, under this test, multiple punishments are permissible if there was a legislative intent to have the cumulative punishments. For example, a defendant can be sentenced both for robbery and using a weapon during the commission of a crime if statute so provided. Lesser included offenses. Attachment of jeopardy for a greater offense bars retrial for lesser included offenses. Attachment of jeopardy for a lesser included offense bars retrial for a greater offense. For example, the crime of robbery includes two lesser crimes of larceny and assault. If a defendant is tried for robbery, they cannot be retried for the lesser included offense of larceny. Similarly, if the defense is first put in jeopardy for the lesser included offense, larceny, they cannot later be tried for the greater offense, robbery. Exception: new evidence. An exception to the double jeopardy bar exists if unlawful conduct that is subsequently used to prove a greater offense, 1, has not occurred at the time of prosecution for the lesser offense, or has not been discovered despite due diligence. Similarly, a retrial for murder is permitted if the victim dies after attachment of jeopardy for battery. There you go. That's what I was just talking about. Effective plea on related offense. The state may continue to prosecute a charged offense despite defendant's guilty plea to a lesser included or allied offense stemming from the same incident. Conduct used as a sentence enhancer. The double jeopardy clause is not violated when a person is indicted for a crime the conduct of which was already used to enhance the defendant's sentence for another crime. So we're on page 76 right now, and there's a lovely table, a chart, another decision tree titled Same Offense under Double Jeopardy Clause. It starts with the question, is the defendant charged with two crimes based on the same conduct? If no, double jeopardy prohibition is not violated. If the answer was yes, you ask, did the legislator clearly intend to allow conviction of both crimes based on the same conduct? If yes, then clearly double jeopardy prohibition has not been violated. If no, or the intent is unclear, you follow that question by asking, does each crime require proof of an additional fact that the other does not, which is applying the Blackberger test. If yes, there's no violation of double jeopardy prohibition. And but if no, if your answer is no to whether each crime requires proof of an additional fact that the other does not. Right, so if they're overlapping elements, then double jeopardy prohibition is violated. Page 77, subsequent civil actions, and the last section will be separate sovereigns before we get to self-incrimination. So we got a little bit more here. Appeals by prosecution, collateral estoppel. So let's finish up this double jeopardy section. In double jeopardy clause prohibits only repetitive criminal prosecutions. Thus, the state generally is free to bring a civil action against a defendant, even if the defendant has already been criminally tried for the conduct out of which the civil action arises. Similarly, the government may bring a criminal action even though the defendant has already faced civil trial for the same conduct, unless it It is clear from the statutory scheme that the purpose or effect of the statute is to impose a criminal penalty. 14.4 Separate sovereigns. The constitutional prohibition against double jeopardy does not apply for trials in separate sovereigns. Thus, a person may be tried for the same conduct by both the state and federal governments or by two states, but not by a state and its municipalities. Skipping all the hypos. Appeals by prosecution. Even after jeopardy is attached, a prosecution may appeal any dismissal on the defendant's motion that does not constitute an acquittal on the merits. Also, the double jeopardy clause does not bar appeals by the prosecution if a successful appeal would not require a retrial. There is no bar to government appeal of a sentence pursuant to a statute permitting such a review. However, if the jury fails to impose the death penalty, the prosecution may not seek the death penalty on retrial after a successful appeal. Lastly, collateral estoppel, section 14.6. which reads, under the doctrine of collateral estoppel, a defendant may not be tried for or convicted of a crime if a prior prosecution by that sovereignty resulted in a factual determination inconsistent with one required for conviction. Module 15, privilege against compelled self-incrimination. 15.1, who may assert the privilege. The Fifth Amendment privilege against self-incrimination can be asserted by any person in any type of case. Only natural persons may assert the privilege, not corporations or partnerships. The privilege is personal and so may be asserted by a defendant, witness, or party only if the answer to the question might tend to incriminate them. And when it says any type of case, I think I would go so far as to say this can be elected at a grand jury hearing, unless I should be aware of that, the opposite from some other source. When privilege may be asserted, a person must refuse to answer a question whenever their response might furnish a link in the chain of evidence needed to prosecute them. The privilege must be claimed in civil proceedings to prevent the privilege from being waived for a later criminal prosecution. Thus, if an individual responds to questions instead of claiming the privilege during a civil proceeding, they cannot later bar the evidence from a criminal prosecution on compelled self-incrimination grounds. Method for invoking privilege. A criminal defendant has a right not to take the witness stand at trial and not to be asked to do so. In any other situation, the privilege does not permit a person to avoid being sworn as a witness or being asked questions. Rather, the person must listen to the questions and specifically invoke the privilege rather than answer the questions. Note, merely being required to furnish one's name after a Terry stop generally does not violate the Fifth Amendment because disclosure of one's name generally poses no danger of incrimination. I guess I didn't really read the next section title because it's called Scope of Protection. At the very end of page 79, at the very top, you get the first subsection, which is testimonial but not physical evidence. The Fifth Amendment privilege protects only testimonial or communicative evidence and not real or physical evidence. For a suspect's communication to be considered testimonial, it must relate a factual assertion or disclose information. Examples of non-testimonial evidence that the prosecution can compel a person to produce include samples of a person's blood, handwriting, voice, or hair. A note on DNA collection. The Supreme Court held that it is constitutionally valid to take a DNA cheek swab after an arrest for a serious crime. Next section, compulsory production of documents. A person served with a subpoena requiring production of documents tending to incriminate them generally has no basis in the privilege to refuse to comply because the act of producing the documents does not involve testimonial self-incrimination. Seizure of incriminating documents. The Fifth Amendment does not prohibit law enforcement officers from searching for and seizing documents tending to incriminate a person. The privilege protects against being compelled to communicate information, not against disclosure of communication made in the past. Section 15.4.4. When does violation occur? A violation of self-incrimination clause does not occur until a person's compelled statements are used against them in a criminal case. I'm reading these bar tips. Only testimonial evidence is protected. Likewise, only compelled testimonial evidence is privileged. Prohibition against burdens on the assertion of a privilege. Comments on defendant's silence. A prosecutor may not comment on a defendant's silence after being arrested and receiving Miranda warnings. Neither may the prosecution comment on defendant's failure to testify at trial. However, a defendant, upon timely motion, is entitled to have the judge instruct the jury that they may not draw an adverse inference from the defendant's failure to testify. Moreover, the judge may offer this instruction sua sponte, even over the defendant's objection. Exception. A prosecutor can comment on a defendant's failure to take the stand when the comment is in response to defense counsel's assertion that the defendant was not allowed to explain their side of the story. In silence before Miranda warnings, note that if a suspect chooses to remain silent before police read them their Miranda rights, that silence can be used against the suspect in court. Harmless error test applies. When a prosecutor impermissibly comments on the defendant's silence, the harmless error test applies. Penalties for failure to testify. The state may not chill the exercise of the Fifth Amendment privilege against compelled self-incrimination by imposing penalties for failure to testify. Elimination of privilege. And grants of immunity. A witness may be compelled to answer questions if granted adequate immunity from prosecution. Use and derivative use immunity sufficient. Use and derivative use immunity guarantees that the witness's testimony and evidence located by means by the testimony will not be used against the witness. However, the witness may still be prosecuted if the prosecutor shows that the evidence to be used against the witness was derived from a source independent of the immunized testimony. I feel like this happens at grand jury proceedings, or hearings, but it doesn't actually say that. Further, immunized testimony involuntary. Testimony obtained by a promise of immunity is coerced and therefore involuntary. Thus, immunized testimony may not be used for impeachment of a defendant's testimony at trial. However, any immunized statements, whether true or untrue, can be used in a trial for perjury. Use of testimony by others, sovereign prohibited. Federal prosecutors may not use evidence obtained as a result of a state grant of immunity and vice versa. No possibility of incrimination. A person has no privilege against compelled self-incrimination if there is no possibility of incrimination. For example, statute of limitations is wrong. Scope of immunity. Immunity extends only to the offenses to which the question relates and does not protect against perjury committed during the immunized testimony. In waiver of privilege, a criminal defendant, after taking the witness stand, waives the privilege to the extent necessary to subject them to any cross-examination. A witness waives the privilege only if they disclose incriminating information. Module 16 is very short. It's juvenile court proceedings. There's two parts: rights that must be afforded and double jeopardy. The following rights must be given to a child during trial of a delinquency proceeding. 1. Notice of the charges. 2. Assistance of counsel. Oh, by the way, that notice has to be written. Assistance of counsel. 3rd, opportunity to confront and cross-examine the witnesses. 4th, the right not to testify. And 5th, the right to have guilt established by proof beyond a reasonable doubt. The Supreme Court has held that there is no right to trial by jury in delinquency proceedings. Pretrial detention of juvenile is allowed where it is found that juvenile is a serious risk to society, as long as the detention is for a strictly limited time before trial may be held. Double jeopardy: if the juvenile court adjudicates a child a delinquent, jeopardy has attached, and the prohibition against double jeopardy prevents the child from being tried as an adult for the same behavior. Forfeiture actions is Module 17. This is the last module, and there's only 2 pages. Introduction. Actions for forfeiture are brought directly against property and are not generally as quasi-criminal in nature. Certain constitutional rights may exist for those persons whose interest in property would be lost by forfeiture. 17.2 Right to pre-seizure notice and hearing. The owner of personal property and others with an interest in it is not constitutionally entitled to notice and a hearing before the property is seized for purposes of a forfeiture proceeding. A hearing is, however, required before final forfeiture of the property. Where real property is seized, notice and an opportunity to be heard is required before the seizure of the real property, unless the government can prove that exigent circumstances justify immediate seizure. 17.3 may be subject to 8th Amendment. 17.3.1 General Rule. The Supreme Court has held that the excessive fines clause of the 8th Amendment applies only to fines imposed as punishment. It does not apply to civil fines. Thus, penal forfeitures are subject to the clause, but civil forfeitures are not. Penal forfeitures. If a forfeiture is penal and the clause applies, the forfeiture will not be excessive unless grossly disproportionate to the gravity of the offense. For example, forfeiture of $357,144 was found disproportionate to the crime of failing to report that sum of money was being transported out of the country. Civil in rem forfeitures. Civil in rem forfeitures generally are not subject to the excessive fines clause. However, forfeitures made under the federal drug forfeiture statute are penal and therefore are subject to the clause. Monetary forfeitures. Monetary forfeitures, for example, forfeiture of twice the value of illegally imported goods brought in civil actions, are not subject to the 8th Amendment. 17.4 Protection for innocent owner not required. The due process clause does not require forfeiture statutes to provide an innocent owner defense. For example, a defense that the owner took all reasonable steps to avoid having the property used by another for legal purposes, at least where the innocent owner voluntarily entrusted the property to the wrongdoer. And that's going to be it for criminal procedures. CMR, which is something mini review.